Hey everyone, so today we're jumping into something called tort law. And I know, it might sound kind of stuffy and old-fashioned, right? But trust me, these legal ideas are like the invisible rules that protect us every single day, from our safety to our reputation. Let's take a look at how these really old principles are still trying to keep our modern world in check.
Okay, to get us started, let's make this personal. Picture this. It's the middle of winter. Your friend pops over and bam! They slip on your icy front step and get hurt. Are you on the hook for that? Well, the answer is tangled up in tort law, which is all about figuring out the duties we owe to each other.
So here's our game plan. First, we're going to look at what you're responsible for right in your own home, on your property. Then we'll explore personal boundaries with the law of trespass. After that, we'll shift gears and talk about the power of words and when they can cause actual legal harm. And we'll wrap things up by looking at your right to just enjoy your own space in peace.
All right, let's start right at your front door. This first chunk of law is called occupier's liability, and it's all about your responsibilities for literally anyone who sets foot on your turf.
So, what does this actually mean? An occupier is basically anyone who has a decent amount of control over a property. And premises? That's not just a house or a patch of land. It could be a boat, a car, even a ladder. So occupier's liability is the rule book for keeping visitors safe in all those different kinds of spaces.
Now, before things got simplified, the law was, well, it was a total mess. The level of care you had to provide depended entirely on who the visitor was. Were they a paying guest, a customer, a friend you invited over, or a trespasser? Each one got a different level of protection, which created this super confusing and often really unfair system.
And you can see that whole story right here. The old, complicated way got a lot of heat from legal minds like Lord Denning, who basically said, "This is nuts. We need one single, common-sense standard of care." And his arguments worked. They led directly to the Occupiers Liability Act of 1957, which just swept away all those confusing old categories and created one clear duty for pretty much all lawful visitors.
And this, right here, this is the core of it, the common duty of care. It means an occupier has to do what's reasonable to make sure a visitor is safe for why they're there. And here's a subtle but really important point. It's not about making the property 100% safe, it's about making the visitor reasonably safe.
So, how does this actually play out? Well, the law is pretty smart about it. It knows that kids are going to be less careful than adults. So, if you have something on your property that might attract a child, an allurement, like some colorful but poisonous berries, your duty of care goes up. But on the flip side, if you hire an expert, like a chimney sweep, you can reasonably expect them to know about the dangers of their own job. And finally, the courts also say that, at the end of the day, parents have the main job of looking out for their little kids.
Okay, on to our next section, which builds on these ideas, the law of trespass. And this is about so much more than just somebody wandering onto your lawn. It's a bigger idea that protects your body, your land, and your stuff from being messed with.
At its heart, trespass is all about intentional, direct actions. We're not talking about accidents here. We're talking about someone choosing to do something that unreasonably interferes with you, your space, or your things, and they have no good reason for it.
So, the law breaks trespass down into three neat categories. Trespass to land, that's the one we all think of. Trespass to the person, which involves any kind of unlawful interference with your body. And trespass to goods, which is just a fancy way of saying it protects your personal belongings from being messed with.
Now, under trespass to the person, you get two words that people mix up all the time: assault and battery. The difference is actually really simple. It's all about contact. Assault is making someone think they're about to get hit. It's the fear of contact. Battery is the actual physical contact itself, even if it's just a light, unwanted touch.
And the third type of trespass to the person is called false imprisonment. This is any kind of total restriction of someone's freedom of movement. What's wild here is that you don't need a jail cell or even physical force. If you lock someone in a room or just block their only way out, even for a minute, that can count as false imprisonment.
Okay, so we've been talking about physical stuff: property, bodies, and things. Now we're going to get a little more abstract and talk about something just as important. What happens when words themselves cause harm? And that brings us to the law of defamation.
You know, Shakespeare absolutely nailed it hundreds of years ago. Your reputation, your good name, it's priceless. And the law of defamation basically exists to protect that jewel of our souls from being smashed by lies.
Defamation actually comes in two flavors: You've got libel, which is defamation in a permanent form. Think writing, a picture, something you see with your eye. And then there's slander, which is more temporary, like spoken words or even gestures, something you hear. The big legal difference? Libel is seen as so serious that you can sue without proving you lost any money, while with slander, you generally have to prove you suffered some kind of real damage, unless it's a really nasty accusation.
So if you want to win a defamation case, you have to prove three things. 1, the words were actually defamatory, meaning they'd make a reasonable person think less of you. 2, the words were clearly about you. And 3, they were published, which is a legal term that just means they were communicated to at least one other person besides you. But here's where it gets tricky. A statement can be defamatory even if it seems totally innocent on the surface. This is called innuendo. The textbook case for this involved a newspaper that published a photo of a man with a woman announcing their engagement. Sounds fine, right? Except the man was already married. So for anyone who knew his wife, the photo implied she wasn't his real wife, and that was defamatory to her. It's all about the hidden meaning.
Now, of course, there are some really strong defenses. The biggest one is justification. If what you said is true, it's game over. It's not defamation. There's also fair comment, which protects your honest opinion on something that's in the public interest. And finally, you have privilege, which protects statements made in certain special places, like in a courtroom or in Parliament, because we want people in those situations to be able to speak freely.
And this all leads us to our final section, your right to quiet enjoyment. This is all about the law of nuisance, and it's basically the rule book for how to be a decent neighbor. It's about balancing your right to use your property with your neighbor's right to do the same. So, a private nuisance is when someone does something that causes a substantial and unreasonable interference with your use of your land. And those two words are everything, substantial and unreasonable. We're not talking about minor, everyday annoyances. This has to be something significant.
So how does a court figure out what's unreasonable? It's a balancing act. They'll look at the neighborhood. I mean, a noisy factory is expected in an industrial park, but not so much next to a quiet suburban house. They'll look at how long the noise or smell has been going on and how intense it is. And here's a big one. If someone is doing something just to be a jerk, if there's malice involved, the court is way more likely to call it a nuisance.
So, let's pull all this together. Occupier's liability means you have a duty to keep visitors reasonably safe. Trespass law is like a force field that protects your body, your land, and your stuff. Defamation law guards your reputation from lies. And nuisance law protects your right to just be and enjoy your home in peace. They all weave together to form this invisible safety net that structures our world.
But that leaves us with one last big question. These laws were created for a world of fences and printing presses, so what does trespass mean when a delivery drone flies right over your backyard? What does defamation mean when an AI makes up a lie about you that goes viral in an instant? The real challenge for all of us is figuring out how to make these ancient, fundamental ideas about fairness and protection work in a world the original creators could never have even dreamed of. Thanks for tuning in.